Joint tenancy versus tenants in common. What the heck is the difference? Hey everybody, I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do will. If you are in Washington State and you need help with those things, cmslawfirm.com. Okay, so there are sort of two ways that you can own property. One of them is called joint tenants with rights of survivorship. One of them is called tenants in common or joint tenancy. Kind of how that can be referred to as well. Just make sure you figure out which one it is. Here's how it works. Joint tenants with rights of survivorship means that if two people own something and one dies, the other remaining owner gets the whole thing. Okay, so if you own a house with someone as joint tenants with the rights of survivorship, and one of the people dies, the other co-owner is then going to inherit and own the entire property. Joint tenants with rights of survivorship. Okay. If you have tenants in common, that is not the case. It is the opposite, essentially. Okay. With tenants in common, each owner owns their half and they can do whatever they want with it when they die. So in the same example, if you and I owned a house and I died, let's say I did not have a will, my half of the house would go to my family, not to you. If I died and I had a will and I gave it to Fred, then Fred would get my half. Okay. So if you own things with joint tenants or with tenants in common, you want to make sure you have good estate planning to make sure that house goes wherever you want it to go. Sometimes the agreement between the two owners is that it will go to the person that is still living. But if you don't do it with planning, then it can be a problem. Okay. Hopefully this helped. If it did, that's great. Hit the subscribe button, follow if you want more. If you have questions, which you might, write them down and I'll answer them. All right. And if you need help with estate planning, go to cmslawfirm.com.